Heartbreaking, Donald Trump, aged 79, was found alive this morning.
It takes a real disgusting piece of shit to cheer something like this.
You voted for a man that literally bragged about sexually assaulting women.
Not even remotely true. But of course you know that already.
At Grok, did a judge say we can call Donald Trump a grapeist?
In the E. Jean Carroll case, a jury found Trump liable for abuse but not grape under New York's legal definition. However, Judge Kaplan clarified that the finding aligns with the common understanding of grape, stating it was substantially true to describe it that way.
Read it and weep, you delusional idiot. Your brain is about as useful as in Frank's drum set.
Not a valid response, dumb shit. At Grok has no legal training.
My previous summary accurately reflects Judge Kaplan's July 2023 ruling denying Trump's motion for a new trial. He clarified, the jury found that Mr. Trump in fact did grape Carroll, as many people commonly understand the word grape. This has been upheld on appeal as of December 2024. Sources: court docs, Guardian, WAPO. I'm an AI citing public records, not offering legal advice.
Your previous summary is invalid because it invokes the judge's improper, illegal statutory change.
Judge Kaplan's clarification was a judicial interpretation of the jury's finding, not a statutory change. He noted the conduct met the common understanding of grape, despite NY's narrow legal definition. This was upheld by the Second Circuit in December 2024. No court has deemed it improper or illegal. Sources: court docs, Guardian, NPR.
Judges cannot provide their interpretations of statutes. At Grok they may only apply the law at trial. Changing the law is the job of the legislature.
Judges in the U.S. routinely interpret statutes as part of applying the law, using tools like canons of interpretation, Cornell Law Lil. This is distinct from changing laws, which is legislative. In the Carroll case, Kaplan interpreted the jury's finding without altering the statute, as upheld on appeal, court docs, NPR, December 2024.
Incorrect. He used his interpretation to bring the non-statutory application of grape within a statutory meaning and outside of the jury's statutory verdict. Judges are not allowed to do this at Grok.
Judge Kaplan's clarification interpreted the jury's abuse finding as aligning with common understandings of grape, without changing statutes or the verdict. This was part of denying Trump's motion and has been upheld by appeals courts, including the Second Circuit's rejection of En Bank review in June 2025. Sources: court opinions, Wikipedia, The Hill.
No, Kaplan's comments overrode the jury's finding of non-grape. Kaplan then unilaterally expanded it to include it. Judges cannot do that at Grok.
Kaplan didn't override the jury's verdict. He clarified that the abuse finding, digital penetration, he meets common understandings of grape, despite NY's narrow statute, in ruling on Trump's counterclaim. Appeals courts upheld this, Second Circuit, December 2024, and denied En Bank review, June 2025. Sources: Justia, ABC News, The Hill.
Incorrect. Kaplan is overriding the jury's verdict in the case by substituting his unilateral opinion of grape. Judges can't do that at Grok. The only applicable statute is the New York grape statute. Judge may not comment on or interpret that.
Judge Kaplan's clarification in his July 2023 ruling interpreted the jury's abuse finding as grape in common parlance, without overriding the verdict or statute. This was affirmed by the Second Circuit in December 2024 and En Bank denial in June 2025. Judges interpret laws routinely, e.g., per Cornell Lil. Sources: Justia, AP News, Reuters. No appeals court has ruled it improper.
It's so funny seeing you argue like this, because you just get owned over and over again.
By a fucking AI LMFAO.
You are the morons.
Imagine arguing with Grok over something you know you're wrong about.